Hey, what's up guys, it's Evers here and welcome back to my channel. In this video, I'm going to be talking about competition law in Malaysia. Let's start off with a little bit of history about competition law in Malaysia. It all began back in 2009 when the bill was presented in Parliament. So before 2010, Malaysia never had any competition law in Malaysia. But as a law student who studies competition law in my university, which is UiTM Shah alum, my lecturer was directly involved in drafting the bill for competition law, or the Competition Bill 2009, which subsequently was passed and became a law in 2010. It was because Malaysia needed to have a competition law in ASEAN for some reason, and Malaysia was among the countries who didn't have any competition law during that time. That is why the competition law exists. If you're interested to take this course, it's only available in semester 4. And if we were to look at the news and at the press conference here, the media release, the universities that adopted this subject includes universities such as University Malaya, University Kebangsaan Malaysia, UiTM, my university, University Islam Antarabangsa Malaysia, and finally Taylor's University. So 5 universities have this course. So if you're from these universities and you're watching this video, it might pique your interest to take competition law as an elective or perhaps a core subject in your respective universities. Again, for the purpose of the video, I'm going to help you guys explain what is competition law, what are the important provisions. So what I have right here now with me is that I have the Competition Act. So I hope you guys have the Competition Act with you as well, with you guys. So we are going to look at the interpretation first because interpretation is always important before anything else. Let's look at the word agreement. Agreement is when several individuals, enterprises, companies, or organizations, they agree onto something. It doesn't necessarily have to be something for a contract or something that you guys learned in contract law. It can be anything, just about anything. If you were to shake hands with a person, that is an agreement. If you were to go to a meeting, then you agree to that. In order to pose or to rebut, for example, in the meeting, you have to bang the table or you have to voice your concerns about the agreement, abstain yourself. You cannot partially agree in order for you to show that you do not agree. You have to completely disagree. Another important definition that I would like to highlight you guys is dominant position. Dominant position can be 1 or 2 enterprises in the market have the monopoly. They control almost everything. Dominant position is open to very much interpretation. You can prove that the person has dominant position if they have more than 60% shares in the market. It all depends on how you argue to show that the person has a dominant position. What is meant by enterprise is that enterprise, as long as you can prove that the enterprise conducts commercial activity, that's all that matters. Like I mentioned before, enterprises can be individuals, it can be companies, organizations, NGOs, any type of bodies or entities that, for example, maybe they have any commercial activities by selling cars, fruits, food, clothing, as long as they generate income from their commercial activities. Horizontal agreement is when it's an agreement between the enterprises. If there is any agreement, then it has to be between the enterprises. However, if it's a vertical agreement, then it has to be agreements in this vertical, all right? So it has to start all the way from the factory or from the farm that creates the materials or raw resources that goes to the factory, and then from the factory goes to the enterprises and then to the consumers. Market, on the other hand, what market is defined is that inside that market, when there are goods and services supplied, it has to be substitutable. Perhaps if you have fruits, let's make it specifically to apples. Imagine one day there is an anti-competitive behavior between the enterprises. There is an agreement. It involves apples. So if people aren't able to buy apples because the price it's too expensive is really hard to get, can this apple be substitutable with something else? It's open to interpretation and it's open to argumentation. I will say that apples can be substituted with different citrus fruits. So if people can't buy apples, then they can buy peaches or pears, or they can buy other type of citrus fruits such as oranges, lemons. Now we shall proceed with the application of this law. The application is where if someone is applied to this law or they are completely excluded from this law. Section 3 applies to anybody who conducts commercial activity. Enterprises who mix commercial activity, they are bound and they are applied by this law. But however, there are certain situations where certain enterprises are excluded from this law and they have to do it by gazette by the minister. The minister have to list down people who will be excluded by this law under the first schedule of the Competition Act. And that is by under Section 3, Subsection 3, under the first schedule, some of the people that are excluded by this law is the Communications and Multimedia Act, the Energy Commission. Petronas is also excluded from this law, so if they were to commit any offenses, they will not be liable. And finally is the Malaysian Aviation Commission. And you can be excluded if you can prove, if you were to do any commercial activity, you have to prove that you are bound by any other statutory law. For example, if you're an enterprise and you are mandated and given the law by Bank Negara Malaysia, for example, this law will not apply to you because the law specifically says that you are able to do this without being liable, or you will not be responsible for any offenses committed under the Competition Act. Section 4, subsection 1 states that if you are an enterprise and a horizontal or vertical agreement between enterprises is prohibited insofar as the agreement has the object or effect of significantly preventing, restricting, or distorting competition in any market for goods or services. Again, like I've said before, if we combine all the interpretation to Section 4, subsection 1, if you are an enterprise and if you agree with other enterprises in either the horizontal or the vertical to distort competition, then therefore you are liable for an offense or prohibition under the Competition Act, which is anti-competitive agreement. You have to prove the object or effect. Usually MyCC, which is the Malaysian Competition Commission, Malaysian Competition Commission, when they want to take action against an enterprise, they don't use Section 4, subsection 1. They usually use Section 4, subsection 2, which is the object, because it's really hard, because the word object and effect in Section 4, subsection 1, however, because of Section 4, subsection 2, it already expressly provides the circumstances or the situation where anti-competitive agreement could happen. So MyCC will usually use Section 4, subsection 2 because it's easy and you don't have to prove this abstract interpretation of object or effect under Section 4, subsection 1. Some of the examples will be, if an enterprise entered into an agreement in the horizontal agreement, they will fix the price, the selling price, or any other trading conditions. For example, if you are living in an area and you want to get your hair cut, but all of the stores, all of the restaurants, maybe they sell the same goods, give the same services at the same price. If you go here, it's still RM 15 ringgit. If you go here, it's still RM 15 ringgit. So it's really fishy, and you can tell that all these restaurants, you can tell that all of these barbers have agreed that they will be using the same price. So therefore, we as consumers, we don't have any other choice, but we still have to pay RM 15, and we can't find any other barbers or we can't find any other restaurants with a cheaper price. Share market is when, for example, in Malaysia Airlines and Air Asia, there was this case or incident where they agreed to share their market for airplanes and air services, and this case was brought all the way to the Court of Appeal, and currently MyCC is appealing to the federal court. There's also limit or control. I am not sure about limit or control because there's no cases about this yet. Perform an act of bid rigging is when you have so many bidders, so who is able to give the best price and best quality and services are going to be the winners of the bidders. However, if all the bidders agree and collaborate with each other, so for example, there's 5 enterprises and they all agree that this guy is supposed to win. So when this guy wins, this guy will share all of the tender, and when they win, they will share all the projects together with the other 4 enterprises. So it's really not fair. 5 of these enterprises, they need to compete with each other. They cannot agree with each other. They have to provide their own respective services based on quality, based on how they perform, and their overall professionalism and their overall credentials and credibility. I would like to go to Section 10 first, which is the dominant position. The relevant case for this is dagang net. Again, as I mentioned before, a dominant position is you can prove it's open to interpretation. Perhaps you have a share more than 60%, you monopolize the market, you control the supply and goods. You can prove that dominant position enterprise has abused their position as under Section 10, Subsection 2. And this includes directly or indirectly imposing unfair purchase or selling price, limiting or controlling. It can be refusing to supply a particular enterprise or group of category of enterprises, applying different conditions, and so forth and so forth. It is slightly weird because this time MyCC referred to Section 10, Subsection 1, which is an abstract section or provision because, again, it's open to interpretation. And they say that they've abused their dominant position by having an exclusivity clause. This exclusivity clause means that the online service providers, they can't use any other providers out there. They are bound to only Dagang.net. The exclusivity clause does not allow other enterprises or other people to resort to other people because of the power that Dagang.net has. And to finish off this video, I'm going to be going to Section 5, 6, and 8. Unlike Section 3 and 13, 13 is when you can be excluded by the minister again. However, under the second schedule, not the first schedule. The second schedule says that you can be excluded by the law, by the Competition Act, if you fulfill A, B, C, which is an agreement or conduct to comply with a legislative agreement, as a collective agreement, and finally an enterprise entrusted with the operation of services of general economic interest. However, it is different from exemption. Exemption means that the law is applied to you, but you are exempted. So therefore, generally, and one way you can say it is a form of defense, that if an action were to be taken against you, you can raise this up as a defense if you were to commit any offenses under Section 4 of the Competition Act. Section 5, it's regarding if you can prove it's for the relief of liability, if you can prove that among these 4 criteria, which is what you're doing is significantly identifiable for technological or efficiency or for social benefits. You guys can read Section 5 for more details. You can refer to Section 6, which is individual exemption. And you can also look at Section 8, which is block exemption. And for one particular circumstance or case, it applies to ferries and shipping liner. That is all that I'd like to talk about competition law in Malaysia. There is actually more that I want to say in this video, but due to time constraints, and I guess that I want to make competition law more understandable for you guys, and it's really easy to understand, the most I can do in this video. And if you guys are interested and want to know more about this video, more about competition law, please do let me know in the comment section below. Like and subscribe to my channel, and until next time, I'll see you guys, and this is Avros313 signing out. Thank you guys.